It ain't every day you see the Supreme Court all nod their heads in the same direction, but when they do, you know something big just went down. This one doesn't wave a big Second Amendment flag, but the way it changes how cops can use force ought to make every armed American sit up and pay attention. What's up, everyone? This is Ted from Line 45, and today we're talking about a Houston traffic stop that went sideways fast and ended up changing the rulebook for the whole country. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable gun-related content on your screen. Now, buckle up, and let's get back to the video. I don't stop everything for Supreme Court news unless it's worth it. And this one sure is. We've got a rare 9-0 call, written by Justice Elena Kagan, that tells every court in the country to judge police shootings by the full story, not just the split second when a shot breaks. That's a big shift back toward what the Fourth Amendment already demands. A totality of heavy circumstances look at whether force was reasonable. Why should folks who carry care? Because context now matters in court, the way it should on the street. A judge can weigh what led up to the flashpoint, commands given, tactics used, whether an officer created extra danger, rather than freezing the video on one frame and calling it a day. The court tossed the Fifth Circuit's momenta with shortcut and sent the case back to be redone under the broader standard. That evens out a circuit split and tells everyone to play by the same rulebook. This all started after a Houston area traffic stop in 2016 turned deadly, and the lower courts kept siding with the officer using that narrow lens. The high court said, "Nope, look at everything that actually happened before the shots." For armed citizens, that means your lawful possession isn't a green light for force in a tense stop. The whole encounter gets weighed. That's dang important if you carry daily and care about how these cases get judged. I'll walk you through the incident itself next, so the facts are clear before we go any deeper. Back in 2016, down in Houston, a simple traffic stop turned into the kind of mess that ends up changing the law. Officer Felix pulls over a guy named Ashton Barnes for speeding. I've read the reports and watched the dashcam breakdown. Things went sideways fast. Felix walks up, there's a short exchange, and Barnes decides he's not sticking around. He hits the gas. Now here's where it gets wild. Felix moves up alongside, ends up on the side of the car, and in about 2 seconds, fires 2 shots into the vehicle. Barnes is hit, the car rolls a bit, and within 5 seconds of that first movement, it's over. No standoff, no long chase. Just a quick, ugly chain of events. Local investigators cleared Felix, and when Barnes's family sued for excessive force, the courts tossed it. Why? They used this moment of threat rule, which only looks at the exact split second when the trigger's pulled. Under that thinking, Felix was hanging off a moving car, so they called it justified without looking at how it got to that point. That's the part that stuck with me. Nobody in those early rulings bothered with the lead-up. No questions about tactics, no real dive into whether things could have gone another way. And that narrow view is exactly what put this case on a collision course with the Supreme Court. Here's the part a lot of folks outside the courtroom never hear about. How the lower courts were actually looking at this case before it landed in D.C. The Fifth Circuit had been writing on this moment of threat rule for years. I'm talking about a legal shortcut where they freeze the frame on the exact second the trigger's pulled and ignore everything before that. Doesn't matter if things were handled sloppily in the minutes or seconds leading up. If the officer can show they felt in danger in that one moment, they're in the clear. I've followed enough of these cases to know that the rule was a sweet deal for the defense. It meant no deep dive into the lead-up, no questions about whether the officer's own moves made the situation worse. And in Barnes's case, that's exactly how it went. The courts looked at Felix hanging onto a moving car and said, "Yup, deadly force justified," without ever asking how he ended up there in the first place. Thing is, not every circuit in the country was playing by that same set of rules. Some have already used the totality of circumstances approach, where the judge has to weigh the whole story, start to finish. That split between courts is what got SCOTUS interested. They don't like it when the law works one way in Texas and another way in, say, California. That clash set the stage for a pretty rare thing, the entire Supreme Court agreeing on how this needs to be judged from now on. What this ruling really does is put some teeth back into the Fourth Amendment when it comes to use of force cases. Before, if you were on the wrong end of a moment of threat analysis, the court would just skip over all the messy details that happened before the trigger pull. Now, judges have to look at the whole ride: what was said, what was done, and whether an officer's actions built up the danger instead of diffusing it. That's a serious change for anyone trying to hold law enforcement accountable. It also means some cases that got tossed out under the old rule might get a second wind. Lawyers are already talking about reopening past appeals where courts ignored the lead-up and focused only on the flashpoint. If you've ever seen how fast qualified immunity can shut a case down, you know why this matters. It doesn't erase that protection, but it sure makes it harder to hide behind it when the record shows a bad chain of decisions leading up to force being used. And this isn't just about high-profile shootings. It's going to ripple into all sorts of Fourth Amendment fights: traffic stops, raids, even simple detentions, you name it. Because reasonableness is now tied to the whole story, not a freeze frame. For someone who carries, this matters more than you think. If you ever wind up in a tense situation, the law now says your fate in court isn't judged in a single second. It's judged on everything that led there. Now, here is where this decision crosses over into our lane as gun owners. A lot of us carry every day, some open, some concealed, and we've all thought about what could happen if a stop or an encounter goes sideways. Under that old moment of threat rule, the simple fact you had a gun on you could have been enough for a court to justify deadly force without looking at anything else. That's not speculation. I've seen cases where the presence of a firearm overshadowed every other detail. With this new totality standard, that changes. The court can't just look at the split second an officer sees your gun and decides to shoot. They have to ask what led up to it. Were you following commands? Was the interaction escalating because of your actions or theirs? Were there chances to de-escalate? Those things matter now. It also means lawful carry isn't automatically painted as a threat in the eyes of the court. If you're legal, and that can't be skipped over just to justify pulling the trigger. For folks in constitutional carry states or anyone who carries in public, that's a big deal. It levels the playing field when your actions are lawful, but the encounter still goes bad. This doesn't give you a free pass. You still have to handle yourself right, but it gives you a better shot at fair treatment if things end up in court. And that's worth paying attention to if you value both your rights and your life. All right, here's where this Supreme Court call hits home for folks like us who carry. I don't care if it's in your waistband, on your hip, or stuffed in the console of your truck. Under that old moment of threat rule, just the sight of your gun could have been enough to seal your fate in court. I've seen it happen. Doesn't matter if you were squared away and following the law. The second that muzzle was noticed, the whole story stopped right there. Now, with this totality of circumstances deal, the court's got to roll the tape from start to finish. They can't skip over the part where you were calm, compliant, and legal just to zoom in on that split second. They've got to ask, was the situation escalating because you were being reckless, or because the officer pushed it there? Were there chances to cool it down before things went bad? All of that's in play now. For everyday carriers, that's huge. It means a holstered pistol in a traffic stop isn't an automatic green light for deadly force in the courtroom's eyes. If you're legal and you handle yourself right, the law now says your case gets the full look, not just a freeze frame. It doesn't mean you can act a fool and expect a pass, but it does mean you've got a fighting chance to be judged on the whole encounter, not a single second. And in my book, that's a win worth talking about. So here's where the rubber's going to meet the road after Barnes versus Felix. This ruling isn't just going to sit on a shelf in some law library. It's going to force changes out in the real world. Departments are going to have to tweak training, because now it's not enough to justify a shooting based on that last instant. Officers are going to be graded on the whole interaction, from the second the lights flip on to the moment it's over. That means more emphasis on de-escalation, better communication, and maybe a little more patience when things start heating up. For the courtroom side, lawyers on both ends are going to adjust their playbooks. Plaintiffs' attorneys have more room to work with now, because they can dig into all the lead-up that used to get tossed aside. Defense lawyers are going to have to prep their clients to explain every choice they made, not just the one at the trigger pull. For folks like us, it's a reminder that carrying means you're part of that totality of circumstances, the second an encounter starts. Every move, every word, every choice can end up in front of a judge. That can work in your favor now, but only if you're squared away from start to finish. This case closed one chapter and opened another. The standard's set, and the message is clear. Courts want the full story. And that's going to change the way force is used, the way it's judged, and maybe, just maybe, the way trust gets built back between the badge and the people.